morning.
Good morning, Your Honor.
Please proceed.
May it please the Court, Barry Franklin, on behalf of Beverly Bart, the appellant, former wife. In this case, I'd like to reserve 6 of my 15 minutes for rebuttal. As Your Honor know, all of you know, this case really revolves around whether or not a minor child, in this particular very unique and complex case, and I use the words unique and complex case as characterized by the trial judge in 2 standing orders. And for sure, if ever a case in the marital context is unique and complex, it is this one. And by the way, this court has dealt with this case on at least already with published opinions, 2 situations. The prior history is important. Everything really starts with the premarital agreement. I know the other side says and takes the position that the premarital agreement, by its language, is only good for the separation. I disagree with that. We don't need to get into an interpretation of the prenup. What is important?
Well, let me ask about that, though. Am I clear that there were no allegations in the motion to intervene filed by the child raising any kind of issue about the need for a declaratory judgment as to what rights the child may have under that premarital agreement?
I don't remember exactly what was in the motion to intervene, but I do remember that attached to the motion to intervene was a proposed intervention complaint. And within the intervention complaint, because I think we had already, I had discovered, remember this is, 2003, 2004 is the divorce, 2011 after a 7-year hiatus, the former husband opens the door, takes the first shot figuratively by resurfacing and filing the modification action. I come into the case much later. The premarital agreement, to go back in a sense answering Your Honor's question, the premarital agreement by its terms in paragraph 33 absolutely says it was an independent contract, not merged, but to be incorporated in the final judgment of dissolution of marriage. To be incorporated. That never happened. Mom didn't do that. Dad didn't do it. For whatever reason, and it's obvious why the former husband didn't want to do it, because he made the promise to pay, expressly pay, guidelines supported in that premarital agreement.
Well, so again, what strikes me is, if I'm processing correctly, the position in the trial court and the position on appeal as to whether or not the child should have been allowed to intervene hinges on the premarital agreement, right?
Not necessarily. That was part of it. The other part of it is there's a statute, an overriding statute. I cited it multiple times in my brief. It's 63212 sub H. That statute is not in Chapter 61, but it pertains to Chapter 61 agreements. That statute says, and it's apropos for this particular agreement, it's in the appendix. This case revolves around the incredible language that appears in that marital settlement agreement. The former husband voluntarily chose to abandon his child. There is language in that handwritten mediated marital settlement agreement that says he is essentially walking away from the child and trying to terminate his parental rights. In exchange for that, there was a sum of money that was paid by virtue of creating the annuity.
So the motion to intervene is also raising this issue about the father trying to abandon his rights to the child?
Well, to basically be able to, because his rights were infringed upon, his due process violated, his property rights compromised, to be able to assert that either he was a third-party beneficiary of the underlying premarital agreement, or that he should be able to, not a duplication of the mother's claims, because the 2 of them are not similarly situated. Yes, the end game to get child support, but they both are not on complete parallel tracks. And so if permitted to be involved through an attorney ad litem, the attorney ad litem for the minor child would have also, remember we never got out of the box on this, we couldn't do anything, but if permitted to be involved, would have also asserted the applicability of 63212 sub H, voiding, not voidable, but voiding that settlement agreement and essentially doing what should have been done from day one on the child support. Every single rule, every statute with regard to that annuity, which vicariously and directly prejudices the child. Every single rule, starting, for example, with child support guideline worksheets, that is non-waivable. There were no guideline worksheets here. There is not even a mention of the child in the mediated marital settlement agreement or the final judgment. This court entertained a petition for writ of prohibition because throughout the entire divorce case, the former husband emphatically was taking the position the child was not his and consequently should not be obligated to pay any child support.
Let me come at it from a different direction then, because my understanding is the case law makes a distinction between a contract to support a child, and I can enter into a contract to support any child, and if I do that, it can be a legally binding document where I'm now obligated by contract to support a minor child that's not mine. Don't even know the child, okay? As opposed to what the case law refers to as a statutory obligation or a common law obligation that parents have to support their children, okay? And what strikes me is everything the mother has been doing, including arguably speaking under the marital settlement agreement, revolves around this issue of a statutory or common law obligation that parents have to support their children, which is separate from the contract. So I thought at first that you were trying to intervene because you were contending that there was this contract obligation out there by the premarital agreement that somehow might have been of more benefit to the child, and that's why you need to intervene, because you're traveling on a contract obligation to support a child as opposed to either the statutory or the common law obligation. But I'm not hearing you, the briefs don't really seem like they're making that distinction. I'm not hearing you today make that distinction either.
Well, I am, and maybe I'm not, and and I'm not trying to be evasive about that.
Well, here's the problem. I mean, I think the law is clear and it's correct. As far as the statutory obligation or the common law obligation that parents have to support their children, there should really only be one person that's entitled to do that.
Generally, I would agree with that.
And if that's the case, then as to that theory of responsibility, you can't have the child intervening in that situation.
So here's the way I can respond. Number one, generally I agree. In 37 years of practicing family law, most of the time, there is no need for an attorney ad litem. You have the classic case where child support is appropriately calculated, all the I's are dotted, all the T's are crossed. This is not that case. And on a contractual basis, to go back to Your Honor's question, on a contractual basis, yes, we are absolutely saying, and I think we made it abundantly clear, at least I hope so, that the child, by definition, by third-party beneficiary definition and doctrine, and there's case law out of this district and all the other districts that allow for an adult child to sue a parent. Forget about the trial judge's thoughts about family harmony, because those cases never would have come into existence, including the 4th District's Brown decision, if there was that impediment. There is one case, as Your Honors know, the Perrygood case out of the 5th District, that allows for a minor child through someone else, it was not an attorney ad litem, but through another family member to sue a parent because, just like in this case, precisely like this case, factually it's a little dissimilar because that was a sham adoption. But here you have a sham marital settlement agreement. You have a very, very wealthy father who, by the way, voluntarily had his name on the birth certificate, who never disclosed what he was worth, never disclosed his income. He had worn down his wife after all that litigation, no fees, no child support whatsoever, and she does the wrong thing. That's my client, and I have said that repeatedly to the court. She should never have entered into that agreement. You know, she had a lawyer, and the court never should have ratified that agreement with all of those important responsibilities statutorily and by rule of family court procedure that were violated. But, Your Honor, what I'm trying to emphasize in answering your question is that there is a breach of contract claim for the child as a third-party beneficiary, but the child also, because there shouldn't be any distinction between a contract and statutory child support law. Because
Yes, there is, because the point is, again, I can agree to support a child that I don't even know, it's not my child. I can just decide I'm going to do this, and I can contractually obligate myself to support a child that's not mine. So there is, in my mind, a very distinct legal difference between a contractual obligation to support a minor child versus the statutory or the common law.
But-
And the other problem I've got is when I look at the premarital agreement, paragraph 25 that speaks about the children, the first line says, each of the parties recognizes that they may have children born to them or adopted during the marriage. And then further down it says, notwithstanding the foregoing, the parties agree that pending any separation of the parties, if they have a child or children, the husband shall pay those sums required by the then prevailing child support guidelines. So the agreement seems to, again, link everything to what would be a statutory or common law obligation. Doesn't seem to be creating some kind of separate contractual obligation to support. So again, I'm questioning what would be the authority for intervening even on a contract there.
Let me go back to this differentiation between contract and statutory derivation for child support. Even where there's a contract, every family court judge is charged with the responsibility to review the contract to make sure that it complies with statutory law and public policy. You can have a contract, and if it appears to waive child support, I'm sure Your Honor would agree that just because the parties freely and voluntarily entered into a contract and did away with child support altogether, and let's say the judge knew the two lawyers, respected the two lawyers, or didn't just read it and signed a final judgment that incorporated that settlement agreement,
But
it wouldn't be permissible.
If what you're saying is the real problem here is the trial court inappropriately approved a marital settlement agreement where dad, in essence, tried to walk away from responsibility and substitute it with an annuity, it strikes me that then the remedy would be, and I don't remember what the family law rule is, but it's comparable to 1.540 in the civil realm, where it's relief from judgment because violates the fundamental principles of law pertaining to children or something like that.
That's exactly the problem, because the mother didn't do that. The mother never came back within a year and exercised what would have been her, and this has been raised against the mother. The litigation has gone a lot further along in the process to the point where, there's already an appeal dealing with the denial of temporary child support. The mother did not do that. I represent the mother. I'm only representing.
And you're also trying to represent the child by the intervention as well, right?
Oh, well, no. I said repeatedly, because I was put between a rock and a hard place. There was an attorney, board-certified attorney, Mark Brower. And by the way, the marital settlement agreement, which has never been disturbed, other things, by the way, the trial court has found serious problems with and done away with, at least here or there, on attorney's fees. But the mediated marital settlement agreement gives the former wife absolute, the equivalent of, it doesn't use these words, sole parental responsibility. So the mother decided when she saw this that she was going to go out and hire somebody to be the attorney ad litem to independently represent the minor child. The father responds by moving to strike the attorney ad litem. motion for reconsideration back in the summer of 2014, the motion for reconsideration is denied. So where does that leave the child? It's a final order on the denial of the intervention. It's a non-final order because at the same time, on behalf of the mother, I filed a motion to amend to bring in an additional party because the case was still going to go on as to the mother and whatever her claims were at that time that dwindled down later on in the litigation. So if I didn't do something because there was no attorney ad litem that was permitted, the child's right to the appeal on the intervention, which was final as to him, would have been lost forever.
Well, let me ask that, and I do actually appreciate the rock in the hard place analogy or suggestion you just made, but then I guess we're using a lot of sayings here. But then doesn't that beg the question: if we permit a child to intervene in his parents' post-dissolution litigation, I mean, you as you say, you've been doing this stuff for 30 plus years. I mean, talk about chaos. If we start letting children intervene because they don't think in this particular situation that mom's asked for enough money. I mean, doesn't even though mom is attempting to do that, doesn't that lead us to a point that we will subsequently wish we had never even begun?
The way you do it is the way the 5th District, I think, did it perfectly in the Paragood case. They said this is a case of first impression, and it was then, the case, Your Honor, that you presided over, that the Davis case that was used as supplemental authority trying to avert the oral argument today. Judge May said in that written opinion, this is a case, we have not found any other cases. Well, guess what? Paragood is about as close and on all fours as you get, where it was permitted. And the other thing that you have to be careful about, I think, you can always say, as courts do, this is an exceptional case, and in every respect, this is exceptional. Particularly where, the Davis case, it seemed to me, that was a duplication. It was an adult child who was pursuing a typical garden variety child-supported rearage case. This is nothing of the sort.
But what makes Paragood distinguishable from this case is the 5th District was very clear to point out that the child was going to be placed on public assistance because of the lack of support of either parent. In other words, the 5th District was saying the courts or government or as a matter of public policy has to step in when the child's support is falling beneath the floor. There's been no argument made, nor do I think you can make the argument that the $60,000 a year annuity is going to place this child beneath the floor. The argument you seem to be making is you shouldn't let children fall beneath the floor, but if you have a wealthy parent who can make the child reach a ceiling, in this case hundreds of thousands of dollars given the father's resources, we should allow the child to reach the ceiling. There's been really no case that stands for that proposition. Government exists to save people from falling beneath the floor, not to reach their greatest potential, as much as we would like that to be the case.
I can respond this way. In Paragood, which I'm holding up in footnote 5, Paragood talks about the parent there and everything is relative. $20,000 in this case on a monthly basis may be the same as $500 for the father in the Paragood case. The father was paying something in the Paragood case, and I don't think it's appropriate to split hairs where that case and this case have one core common applicable statute, which is 63212. I keep going back to that because every time that I mention that at the trial court level below, and by the way, it's codified in 2 of the subsequent orders, there has been no defense to it. There has been no case. Because,
But
and the father...
63 deals with adoptions. I mean...
No, it doesn't. It says very specifically, now I take issue with that respectfully, Your Honor, it's for any case. It is unlawful for any purpose to contract for the purchase, the sale, or the transfer of custody, or parental rights in connection with any child in return for any valuable consideration. That's what happened here. And the statute makes it clear. It is void. When you do that, it is void. Void means, to go back to Your Honor, Judge Connor's question before, well, the mother should have filed a 1540 motion. Well, guess what? Sometimes there is a period of time, you commit fraud in a financial affidavit, there's no statute of limitations. This is equally, if not more important, if the statute says, and it does, clear, black and white, that it is void. That means, in this case, as it stands right now, the child is not involved. The mother ought to be able to make that successful argument to the court, notwithstanding the baggage that she has because of all the contract defenses that the father has, and by the way, raised successfully. None of those defenses apply to this child. So I understand the policy considerations about, well, if we do it in this case for this particular child, my gosh, the floodgates will open, and every creative lawyer where there's a little bit more money than the average is going to come in and say, I want an attorney ad litem to represent the child. I get that. But if it's crafted the right way for the right reasons, because the Davis case did not have these unique features and issues, nor did it have the application of 63212. So either by way of the prenuptial agreement, and again, if you look at paragraph 33, it was to be incorporated. So whose fault is that? Whose fault is that? It's mom's fault and dad's fault. And dad obviously had his own good reasons why he did not want that premarital agreement in there. But to go back to Judge Connor's question or issue, it doesn't matter, because the law of this state universally is you start with statutory guideline child support. So it doesn't matter whether it's helpful, certainly, that he said expressly, I'm going to pay guideline child support, and never pays not one penny, let alone anything close to guideline support, and does everything within his power to make sure that mom can't find out what the guideline calculation would be. She doesn't know that until a few months ago. So I'll reserve the rest of my time, whatever I have. Thank you for the questions.
You're negative 6.5.
Not probably,
that's
but
okay.
I was
We'll
getting
give you
hit with a lot of questions.
I know. We'll give you a minute to
Thank you.
rebut.
Whatever you give me is appreciated.
May it please the court. Jane Corza Walsh here on behalf of the appellee Bart-Swezy, the former husband. With me is my associate Stephanie Serafin. The issue here is standing, not the merits of this case as we have become so distracted. And the trial court properly found that the former wife, on behalf of the minor child, lacked standing to intervene in his mother's child support modification action.
Ms. Gross, let me ask you this question, though. I mean,
Yes, sir.
I think it's fair to suggest, you're right, this is a standing case, but Paragood, the argument was made there's no standing, and the court there, the Fifth, carved out standing. So why couldn't we do that here, given this unique set of circumstances?
First of all, this is not a unique case. And your observations were right on the mark, and Judge Gerber's observations were right on the mark. There is nothing unique about this case, except that the former husband does have a lot of money. And the former husband has been supporting this child to the tune of $60,000 a year. And the former wife, much to my opponent's chagrin, in her own pleadings at 723 and 724 of the record, admitted that the annuity was and is child support. In her own pleadings, she said in a motion to compel the former husband to pay taxes that the annuity is child support. So she has been litigating all of this for all these years, when in fact she said it's child support. So let's ignore that for the moment. Paragood, in that case, said, under the unusual and unique facts of this case, which was a sham adoption, first of all. Secondly, as Judge Gerber pointed out, we had the parents there not paying a dime of child support for their child. That child ended up on public assistance. In the final paragraph of that case, we have the court saying, we think the Mistretta case, which the case that the father had been relying on, is not on point, and they say it's not on point because the interests of the child were fully represented by his parents. Mistretta was a child support case, not an adoption case, in which the child's economic interests were de facto fully protected and argued by his mother. That's exactly what's going on here. We have a child support case. We have a case where the interests of CS are fully represented by his mother, and in fact, being litigated at this very moment by his mother, who is arguing exactly the same issues that want to be argued by CS in this proceeding. So what is being lost? What is to be gained by having CS intervene? Absolutely nothing.
A cynic would say that what the mother has to gain is to substitute this child for herself and therefore avoid the possible penalty under the marital settlement agreement of having challenged the agreement in some way and being subject to fees.
That could happen, except as we know, the penalty has not been enforced because fees have been awarded in other circumstances. So that penalty has really not proven to be a penalty. So that's a hollow penalty. We know from the Howling case that only one cause of action exists in response to Your Honor's question. And that cause of action, in the case of the disability of non-age, belongs to the parent, and it gets enforced for the benefit of the child. As I said, the Paragood case is not remotely on point. The Southard case out of the 5th District says, and I quote, that child support is a statutory cause of action. It's not a contractual cause of action. So the child support cases are not remotely on point when you're dealing with college expenses, which are the cases that my opponent is relying on. So those contractual cases, don't look to those. The Brown case, don't look to that case, because that again is a college expense case. It's not on point. We have to look to Davis. Davis is exactly on point. And this court, Judge Sickland, you were on that panel, said, we have never held, nor has any other court held, that the rights that accrue during the age of minority can be enforced by anyone other than the child's legal representative. That is where this case should end. There is no standing for CS to intervene in this case. This case, the trial court properly found that there was no intervention here, that the child's rights were properly being enforced by the mother, and there was no reason for him to intervene in this case.
What would your argument be if, in fact, the father was using that penalty clause? Would your position be any different?
No. No, there's still no standing, Your Honor. There's still no standing. And unless there are any other questions, we rest on our brief and ask you to affirm. Thank you very much.
We'll give you a minute here if you want to rebut.
Yes, absolutely. One thing to crystallize, I said it in the brief, but especially in light of opposing counsel's argument, there is a distinction because every district, the 4th, the 2nd, the 5th, the 3rd, has permitted a child, an adult child, to have a cause of action against a parent. The fact that many or most of those cases may be college education, the obligation in a contract became an obligation in the nature of child support, and it was subject to the court's contempt power. And the 4th, this court said in 1998, it's either the child or the parent or both. I think, to go back to the Davis case with regard to Brown and by the way, the 3rd district in Rudnick versus Solomon, that's in our initial brief, page 31. That was an 18-year-old child that was permitted to intervene on a child support question. So there is law that is out there. The real question is, are you going to extend it, at least in the 4th district, like Paragood in the 5th, to say in a unique, exceptional set of circumstances, because when counsel says this isn't unique, how is it not unique when they agree upon a number, they don't follow any of the statutory or rule of procedure laws to suggest how that number was arrived at, to show what the guidelines were, to, if it wasn't the guideline amount, to explain why, that's what a judge is supposed to do, to explain why the departure, downward departure deviation for the lower number. That was never done, and there is no excuse for it. And that is part of the responsibility of the mother, not just the father. As far as the fees, I think that question was apropos. You know, in the relocation, which is before this court, I don't know if it's the same panel, the relocation fees, after the father lost, after Senior Judge Barry Stone granted the final judgment for relocation, and finding in that instrument that the father had not done anything, never paid any guideline child support or anything close to it, the court determined that, I lost my train of thought because I know I'm so close out of time. I just lost it there for a second. But anyway, the fee penalty, that's what it was. The father was attempting to assert a fee claim against the mother for the privilege of losing the relocation, even though the court found that it was in the child's best interest. There is no definitive ruling from the trial court that fee provision is universally dead. It's still out there. It still creates a sword and a shield. The fact that the court has, on 2 occasions, individually set it aside, but the court did away with our complaint for declaratory relief. The claim for declaratory relief no longer exists. So for all the reasons that are articulated in the brief, and hopefully the best effort that I made on the answers to the difficult questions, because this is a difficult area, and the law is not very easily reconcilable. Paragood is out there, and I think that it is as close as we get, and Your Honors should allow the child to be involved through an independent attorney ad litem. Thank you.
Great, thank you. Okay, we are, based on this clock and that clock, we're gonna take